Today we're going to be talking about 5 USCIS policy changes that have gone into effect in 2025 that might affect you or your family members when you're applying for benefits with USCIS. So the first one, in my opinion, is the most important. It's that any application for adjustment of status and some other applications that get denied by USCIS will almost automatically get a notice to appear, an NTA, which begins deportation proceedings. So for example, if you file a green card application and it gets denied, there is a very high probability that 6 months later, you're gonna receive a notice to appear in immigration court, and now you're gonna have to defend yourself in removal proceedings. So it's really important that you not make any mistakes when you submit your green card application and other benefits as well. If you need any assistance with anything like that, you could always feel free to reach out to me or my office and see if we can assist you with your case. The second thing that has really changed, and this is very recently, probably April, May 2025, this has gone into effect, is that any I-130 family petition that's filed for someone who entered the US without inspection will get referred for a notice to appear in immigration court after a decision is made on the I-130. I'm gonna do another video specifically on this topic and what options you might have if you have an approved I-130 and you are placed into removal proceedings. Typically, the reason someone would be the beneficiary of an I-130 if they entered the US without inspection is so that subsequently they could file a 601A unlawful presence waiver and try to go back to their home country to attend a consular interview to re-enter the US as a permanent resident. But this puts a wrinkle in that plan. If you're placed into removal proceedings after I-130 gets approved, you might not really have the opportunity to wait 4 years for a 601A unlawful presence waiver to get approved. So you might need to consider something else like cancellation of removal, which I'll talk about in a separate video. The third change that I've seen go into effect in 2025 is that all green card applications are getting interviews. It doesn't matter if it's a marriage-based case, or you petition for your parent, or you just have a green card application pending after you were granted special immigrant juvenile status or a U visa or whatever. All I-485 applicants are getting green card interviews. And the reason for this policy is to slow down the benefits that USCIS is able to issue to immigrants. Before, an immigration officer could approve many green card applications in a day, like 50 green card applications in a single day if everything seems to be good on paper. And that included marriage-based green card applications. In fact, I would say 90% of my green card applications for marriage-based cases in 2024 got approved without an interview, which really sped things up and allowed officers to get a lot more done. But now they can only really get like 8 to 10 green card applicants in for an interview in a single day per immigration officer. So it's really gonna start slowing down the benefits and causing massive backlogs. And that actually segues nicely into the fourth change that I've seen. So USCIS officers now are not allowed to work from home. All of their alternative work schedules have been effectively canceled. And now they have to spend a ton of time commuting, and now they can also no longer do overtime, which makes no sense because it wasn't like the taxpayer was paying for their overtime. USCIS is a self-funded program that's paid by user fees. So when you apply for your green card and you have to pay $1,440 just for that green card application, that's going to fund the salaries of the USCIS officers and the other parts of the operation that require funding. So this is just a blatant attempt by the Trump administration to cause attrition amongst the USCIS ranks. And I did another video about this last week. You're seeing a lot of USCIS officers that have been lifelong public servants quitting, and they are not being replaced. So we expect processing times to double in the near future. And the final big policy change that I've seen recently is that all of the Biden era humanitarian parole entrants, the people who entered the US with humanitarian parole, everyone of those people who has a green card application currently pending has been paused. And now we are waiting for litigation to process to see what happens with all of those applicants. I do believe that they will eventually have their green card applications approved if they are approvable. I don't think they're gonna be permanently denied or permanently canceled, but that's another change we're seeing right now. And if you want to see what happens with that, be sure to subscribe because I'll always keep you guys updated on those immigration policies. All right, guys, that brings us to the end of today's video. Those are 5 changes I've seen very recently be implemented. If you're interested in topics like these, be sure to subscribe. If you personally need any assistance with a family-based immigration matter or naturalization matter, or you just want to consult with an attorney to answer some of your questions or anxieties, feel free to reach out directly to me. You can find my information in the video description below, and I'll see you guys next time for another video.